Okay, did we get it? I think we got it. I think we got it. Okay. Hi, hi, hi. Come on in. Come on in, everybody. We're still waiting. We still have a few minutes, so I am still getting this set up. This is my first YouTube live listening to court arguments, so that's exciting, right? Hello, hello, hello. Hello. Let me just make sure this is actually going here. Oh, yep, we are. Okay. Yep, we're live. Hi. Hello, hello. I did just put out an announcement on the TikTok, so we'll see if anybody joins us here. We'll just have to see. Hello, hello, hello. Welcome in. Hopefully, some people saw my announcement. I'm making the switch, everyone, so it's gonna take some time. All right, it's gonna take some time to make the full switch over to the tube of you. I'm very excited, though. I'm very excited. This is a huge issue we need to get sorted out. So, hello, hello. Hi, everybody. Come say hi if you can, so that I know you're here. I'm still trying to figure out how everything works here. So, hopefully, hopefully we're up and running. Hello. Hello. Oh, I'm so glad somebody said hi. Hi, I'm just sitting here talking to myself. I'm like, what? Is this thing on? Are we on? Oh my goodness gracious. Welcome in, everybody. Welcome in. I have to say, just right off, that it was Taylorina who was so sweet to give me this heads up. And she's been talking to me. We've been going back and forth about what's been going on. And she's been letting me know. So grateful to Taylorina for giving me the heads up on this. Hello, 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 Ashley. So, yeah, we're going to listen in on the U.S. Court of Appeals, D.C. Circuit. We're going to be hearing about the Alien Enemies Act here, which is the issue that's in front of them. So, very interesting. I think just a couple days ago, they put out a press release, I guess, saying that there was going to be oral arguments today, but it wasn't really publicized very well. I know MSNBC has it going. I am actually on the Court of Appeals YouTube, so I'm not using a different website. I'm just following the Court of Appeals straight up. So, no issues there with information coming in. And I'm putting one of my nails back on. So hopefully everyone's having an okay day. Is it Monday? I'm not sure. It feels like Monday was a week ago, but it was just like 3 hours ago. I don't know, everybody. My time's a little bit messed up. But welcome in, everyone. Again, this is the Court of Appeals in the DC Circuit, and they're going to be hearing arguments on the Alien Enemies Act situation that we're kind of all keeping an eye on regarding El Salvador. This was an act that was passed in 1798. It was one of four different pieces, and only two of the pieces actually passed in 1798. The other pieces, Kentucky, I think, and Virginia, passed later. So anyway, it was a four top that kept coming through. That was signed eventually by John Adams. So can't keep track of the days. Oh my gosh, I know. I know. They're kind of they're all blending together. Yep, I know it. And I remember this from the first administration. I remember waking up in the morning being like, "Did I sleep? I don't even know if I slept. Like, what's going on? I'm not happy about it, but all right." Yes, there's a lot of that going on. There's just so much going on with all of these lawsuits filed against the Trump administration. It really is amazing. The sheer quantity of it is amazing. I'm hoping to get some posts together to give updates, but there's just so much going on. My goodness, everybody. Hello, Lola. Welcome. Welcome in. I know this is kind of last minute, right? I had been trying to get the timing sorted out and wanted to make sure everything was going. And it looks like it should be up and running here in just a couple minutes. So, no, no, not yet, Morningstar. Haven't missed anything yet. We've got, it looks like 988 people watching on the Court of Appeals website. So, this is their YouTube channel, everyone. And they're just about ready to go. So, they're just about to have arguments. And I've got, this is my first time over here doing this on the YouTube. I'm very excited about it. I'm very excited about my move over here. So we're going to just wait. Should be any time we should have the judges coming on. We have a 3-panel judge, or so that means it's possible, depending on their decision, that it could go en banc or it could get appealed up to the U.S. Supreme Court after this one. They just stream the audio. Yes, yes. We don't have cameras in the federal courts, but we do have the audio, which is amazing because our district court level, the court below this one, did not have audio available for recording or for streaming. So we just had to like take notes. Hello, 5:30 p.m. Hello, Deborah. Good to see you. Welcome, welcome. Yes, I'm good with that also. Yeah, I'm very excited here. I'm trying to hold myself back. We did just get an opinion. So the judge for the DC judge, the lower court, just issued this opinion about two and a half hours ago. And I've not read through it yet, but he came out and said, yeah, so he wasn't very happy. The defendant's motion to vacate the temporary restraining order is denied. And he wrote about that for 37 pages. So I'll be looking into that later to see how he went down that road. So thank you for joining me, everybody. Again, very last minute. This is my first time doing this one on the YouTube. So I'm so grateful everyone can come and join me here. All right, so we are watching the actual YouTube for the Court of Appeals. So we should be able to hear it starting here pretty soon. Oop, did I hear it? I'm not sure. Wait, was that Atticus? Was Atticus sneezing? Oh my gosh, I have a sneezy cat, everybody. Super sneezy, letting me know. Yes, I'm so glad too. Yeah, I put a post up on my TikTok, and I'm just hoping the notifications are coming through. I really did not plan this well. Oh, thank you so much, Deborah. Oh, I appreciate it. I appreciate it so much. Yeah, I'm still trying to get everything sorted out. Glad you're on. Yes, yes. Well, I mean, this is a pretty huge situation going on here. So we definitely have to keep an eye on everything. Although it looks like it should be starting anytime now. Where's my popcorn? I didn't make any yet, but I could use some popcorn right now. Yeah, it's huge. It's a huge issue. This one is just so like shock and awe huge. And oh, good, Isabel, I'm so glad you saw it. But the frozen funds, that's the one that's doing the most damage right now. It's a different kind of damage, of course. So this one, we're dealing with freedom and really life and death situations. But the funding is the fundamental separation of powers issue. So, yikes, a lots to get sorted out here. Oh, I hope they come on pretty soon. Man, we got spoiled by the district court, the court below this one, because they were setting it up and knocking it down like within 30 seconds of the. Oh, here we go. Oh my gosh, here we go. I'm so excited. Okay, here we go. Hi, Feisty. No clapping. That's all right. Okay, here we go. Let me know about the volume. They stopped talking, so.
Good afternoon.
Ooh.
May it please the court, Drew Ensign, Deputy Assistant Attorney General for the United States. The district court's order represents an unprecedented and enormous intrusion upon the powers of the executive branch. It enjoins the president's exercise of war and foreign affairs powers under the Alien Enemies Act, and does so in a manner that purports to direct operations outside the United States borders and in a manner that could intrude upon sensitive diplomatic negotiations. The basis of that order was explicit second-guessing of the president's determinations that the statutory preconditions of the AEA were satisfied for a foreign terrorist organization, Tren de Aragua, or TDA. Even though both the Supreme Court and this court have explicitly held that such challenges are not within the powers of federal courts to hear. The district court's order is therefore appealable, much as a TRO directing the president to redeploy a carrier group from the South China Sea to the Persian Gulf, or to halt.
Hang on.
Oh.
I mean, one of the claims pressed here, which the Supreme Court has expressly said, and we have said, courts can entertain, so put aside interpretive questions about whether there's an incursion or invasion, is whether these individuals qualify under the terms of the proclamation, whether they're members of Tren de Aragua. I assume, as below, the government does not dispute that is something courts can adjudicate, correct?
Your Honor, it's certainly something that courts have adjudicated in individual habeas claims.
That's a separate thing. The courts can do that. And so asserting a power to do that is not ordering ships to relocate in foreign waters, right? That is straight up judicial process that's allowed by the Supreme Court and circuit precedent. Actually, you have your argument then about habeas, right? But that's a procedural point.
Well, she's not even
Your
playing.
points about him overstepping, seem to be forgetting that there is this claim, and in fact, this morning, he's limited the TROs to the likelihood of success to that prong. And so we don't need to go any further than that, correct?
No, I don't believe so, Your Honor. Because the government has taken appeals of the TRO, the district court didn't have jurisdiction to change the basis of the TRO. And so
that was one of the bases all along.
I disagree, Your Honor. The bases of that order were set forth on page 41 of the transcript from the Saturday hearing, and they were expressly limited to just those second guessing of the president's determinations that the statutory preconditions of the AEA had been satisfied.
If we read the record differently, if we read it to include these claims, having been pressed from the beginning, and including at the hearing, it's insane from their complaint that their clients, at least the ones that we have, the named plaintiffs and some of the other ones, are not members of Tren de Aragua and had no chance to demonstrate that when they were rushed onto airplanes and flown to El Salvador, or are at risk of being rushed onto airplanes and flown out of the country. And so if we read the record that way, then we don't have to get into these other questions, correct?
No, I
Whoa.
don't believe so, Your Honor. And
So we don't have to, or, no, I'm wrong?
I guess I would say several things, Your Honor. One is that the district court's order goes well beyond merely preserving the status quo. It purports, as the district court explained, to order the president to conduct operations outside U.S. borders in a particular way. He directed that the executive branch either turn planes around or to find another way to operate internationally.
Right, but that's, so, I mean, at this point, my understanding is that the government has been complying with the TRO. Obviously, it doesn't extend to people who are being deported on grounds independent of the proclamation. So when I say complying, that there are no planes now en route out of the country with people covered by the TRO, correct?
That's my understanding, yes,
No
sir.
planes on the ground anywhere in the world with people covered by the TRO that would have to come back.
And Your Honor, let me just
Right?
first clarify.
Is that factually right?
I believe so, Your Honor, though let me clarify one thing about that, which is that the district court's order only applies to those that would be removed under the Alien Enemies Act.
I'm not sure who
It
the
does not
judge is.
apply to those that may separately have final orders
Right.
removed under the INA.
That's right.
Yeah.
Sorry, I wasn't clear. I was trying to say that up front. If there are other grounds for
Yeah.
moving them out of the country, he was quite clear. It was clear again this morning, but it's been clear from the beginning, that's never been enjoined under the temporary restraining orders.
That's correct, Your Honor.
Right, so we're not talking about those. You might have planes with people going other places because
Yeah.
they've got ordinary orders of deportation.
I think that's right, and I apologize, Your Honor, I think we're agreeing, and
Okay, no, I was clearly me not being clear enough, so clearly me not being clear. So now, to clarify again, my question is, the concern about ordering planes back and forth is moot at this point. That's over and
She's
done. There's nothing we
really
could do
narrowing the
to
point.
address that. Nothing we could do to remedy that, even if we were to agree that that shouldn't have happened. That's a question, but it's just moot at this point.
I don't believe so, Your Honor. I think the district court
Ooh.
understands the government to be under a continuing obligation, having not turned planes around to find some other way to return the people. I don't think the district court has interpreted its TRO as no longer being operative. And so I think that continuing aspect of it supports appellate jurisdiction here.
You read it as requiring the return of people who are no longer in U.S. custody?
Your Honor,
Whoa.
the government does not believe that the oral pronouncements as opposed to the written one is binding, but as
too
the
far.
district court appeared to have a different view, his oral order provided for two ways of compliance, either turning around the planes or finding a way to return.
He's arguing the
people
contempt
to the United
question,
States. The first option is no longer available.
not
but
the
district
TRO
court has not said
question.
that the second option
I don't think the
is
judge
not,
is going to permit it.
is not still in force.
And much of this, I think, has to do with the compliance issues that are, I think, separate and
That's what she just,
go forward
yep,
regardless of what happens with TROs.
yep.
And so, as of right now, your concern is that if the TROs, for your sake, say even the written TRO, so the written version of the second TRO is in place, what language in that requires the retrieval of people from U.S. custody?
Your Honor, I think
Sorry, let me clarify again, that are no longer in U.S. custody?
Your Honor, it's not that it would not be the written order. I believe it's on page 43 of the Saturday transcript.
Right,
It was
right,
a
Evelyn.
directive, but more broadly too, this is a nationwide TRO that enjoins the president from using any of his AEA authority to remove people during this period. That is
But
something.
that's different. That's not ordering ships around in the water. That
It-
is, and that's not ordering planes to go anywhere. All that the TRO, the nationwide TRO says is folks that are detained and folks can still be detained under the AEA. They just cannot be removed from the country until this point, until I guess you get a preliminary injunction decision from the court, which looks to be forthcoming soon.
I agree that the district court looks like it may be acting on a preliminary injunction soon, but I think the intrusion upon the war powers and foreign policy powers of the president is utterly unprecedented. And
Oh,
in
dear.
a way,
Well, this is an unprecedented action. as well. So of course, there's no precedent for it because no president has ever used this statute this way, which isn't to say one way or the other what it can be done, but simply to say we are in unprecedented
Wow.
territory. But I'm just trying to really clarify here, if you agree that, and I believe you agreed in district court, I think you agreed here, tell me if I'm mishearing, that these folks have a right under the AEA, under precedent, to challenge their status as individuals subject to, that fall within the terms of the proclamation here. That is, I think most relevantly, whether they are members of Tren de Aragua, although maybe they deny Venezuelan citizen status too, I don't know. But the big one that seems to be in the papers is, they said, we're not even members of this. In fact, some of us are fleeing from Tren de Aragua. Is it your position that temporary restraining order that simply prevents removal until there's procedure and opportunity in place to address whether they even fall under the proclamation? Are you arguing that that is an unwarranted intrusion on the president's powers?
Yes, Your Honor. I think whenever a district court enjoins the president from exercising his war and foreign policy powers on bases that are manifest error, that is absolutely the sort of irreparable harm.
So, but the injunction doesn't have to be against the president. I mean, the president said, I only want people who are members of Tren de Aragua removed. And so if his lower level executive officials are removing people who are not, or we don't know are members of Tren de Aragua, the problem is not with the president's proclamation, it's with its implementation by lower level executive officials. And that's against him the TRO runs. So there's nothing there about enjoining his war or national security powers. That is all
dear.
about lower level folks who are not implementing the terms of the proclamation because they're not making sure these folks are members of the gang before they remove them.
Your Honor, I disagree with that for at least two reasons.
What?
First of all, that's
Oh,
simply not
she's
the
getting
basis
him.
of the TRO that was appealed. Again, on page 41 of the Saturday transcript, you'll see the basis that the district court gave for its second TRO, and that basis was explicitly not on having anything to do with individualized determinations that people were members of TDA. It had to do with second guessing the president's determinations that there had been an invasion or predatory incursion or threatened or attempted of the same, and that
46, is that right?
41 of the Saturday hearing. Let me.
March 21st, right?
Yes, Your Honor. Let me get to that specific language. So what the district court said in explaining why it was issuing a TRO was, I think they, plaintiffs, have certainly presented a serious question that the president's proclamation is not legal under the AEA or a, sorry.
Make sure I'm on the same page as you. I'm looking at
The judge is trying to clarify that
This would be the,
his argument's too big.
and
I think the transcript has line numbers, so if you could tell us the line number you're starting with.
That's the
I think I have
second
it,
judge.
So we're all on the same page.
yes, Your Honor, it's page 41 beginning at line 12.
So this is, he's saying it's a question about an issue
Sorry, let me
of
pull that.
power for the president. The judge is saying this is about the
So what,
restraining order.
What the district court said was, I think they, plaintiffs, have certainly presented a serious question that the president's proclamation is not legal under the AEA, or a different way of saying it is that the AEA does not provide a basis for the president's proclamation, given that the terms invasion, predatory incursion, really relate to hostile acts perpetrated by enemy nations and commensurate to war. Also, the terms nation and government do not apply to non-state actors like criminal gangs. And then he goes on without ever referencing.
But that's
you know,
the argument
opportunity
for
to
the whole
make challenges
case,
to individualized determinations,
not the
under
restraining
AEA.
order.
So I think that's the order that you have before you. That's the order that we took an appeal of. And its basis is specifically the sort of second guessing of the adequacy of the president's determinations that statutory preconditions of the AEA have been satisfied. And the Supreme Court's decision in Ludecky and this court's decision in and Citizens Protective League specifically preclude such review. Here's how the Supreme Court described it in Ludecky. The very nature of the president's power to order the removal of all enemy aliens rejects the notion that courts may pass judgment upon the exercise of that discretion, end quote. Similarly, this court in Citizens Protective League recognized that, quote, unreviewable power in the president, ... is the essence of the act, end quote. The binding holdings of Ludecky and Citizens Protective League are controlling precedent here. And both plaintiffs challenged the president's determination that one of the statutory preconditions there, whether there was a war that could justify invoking the act, was satisfied.
He's going
In
too
both
far
cases, plaintiffs had very strong factual arguments.
for the restraining
World War
order.
II had long since ended as a practical matter, and victory in Europe Day had been declared years earlier. As Justice Black noted in his dissent, the very idea that World War II was still ongoing at the time of Ludecky
No,
was,
that's
quote,
not Blanche.
pure fiction.
No, that's another
None
fella.
of that mattered, however. President Truman's determination that World War II had not ended simply was not reviewable. Federal courts therefore lacked jurisdiction to hear challenge to the president's findings that the requirements of the AEA had been met. The same result must obtain here.
He's saying the court
As
didn't
in
even
Ludecky and
have the
Citizens Protective
authority
League,
to
plaintiffs
do
are
the
bringing
restraining order.
facial challenges to the president's determination that the conditions for invoking the AEA have been satisfied. And there's no basis for concluding that the president's determination that there is a war is wholly unreviewable, but determinations that there has been an invasion or a predatory incursion or threatened or attempted of the
Thank you,
same
Steffi. Yep.
is somehow reviewable.
He also, but he said, and again, I apologize, but I think this is line 10 to 11 of 41.
Right, Isabel. Yep.
It's outside of what Ludecky talked about. It's outside of it. And we know what was outside of what Ludecky talked about, and that was the individual determinations as to their qualification, as to whether they qualify under the order. I mean, again, there's no question
Right.
that can be done. That's been argued in this case from the beginning, it's in the complaint, it's been argued about. That's the basis on which the government keeps saying you have to do this through habeas. There's just no question that he was basing it on multiple things, and one of which, and we now have the clarification from the district court judge this morning, is it's just about, all it has to rest on now in denying your motion to vacate is the right of them to have an opportunity, and there's no procedure as implemented by lower level officials that allows anybody an opportunity to challenge their status.
Your Honor, I simply
The TRO rests on that. To the extent, I understand that there's language on both things here, but to the extent it's resting on that, and that's what we've been told this morning, and it's here as well. So
Well, I
it's part of
think
it here, and it's
attorneys can
clarified now.
argue anything.
To the extent it's resting on that, there isn't an impermissible intrusion. It's fully consistent with our precedent in Clark and Ludecky, correct?
No, Your Honor, I simply don't agree with that. I think he told us on page 41 explicitly what his reasoning was, and I think you're reading a lot into that additional language in a whole nother holding that now exists in 37-page opinion form, but did not exist when the order was appealed and is not before you.
Can I ask, one of the things he said today, I just want to see if there's common ground between you and the plaintiffs and the district court. He said, before they may be deported, they are entitled to individualized hearings to determine whether the act applies to them at all. I think you agree with that. Do you agree with that?
I agree with part of that, Your Honor, in that he cites to a number of different cases that allow for such review in habeas proceedings. And so to the extent that someone were to bring a habeas challenge, review of some sort along those lines is.
No, I'll use your words and then make sure that we're on the same page.
Oh
To
dear.
the extent that it's brought in an individualized habeas challenge, they are entitled to individualized hearing to determine whether the act applies to them at all, correct?
Your Honor, there's certainly precedent to support that. It's not precedent of the Supreme Court, so the exact contours of what a habeas court might hold are unclear, but I will certainly acknowledge there are cases, there are habeas cases that exercise review, certainly of that sort. Ludecky itself exercised review over a due process challenge, and that was reviewable. It just simply had no merit whatsoever. This court itself and Citizens Protective League exercised similar review over constitutionality, but again, just thought there was no merit there.
Well, let's say that, 'cause I understand you not to be affirmatively endorsing, but not to be affirmatively contesting the statement that if they bring it in an individualized habeas petition, they're entitled to individualized hearings, determine whether the act applies to them at all. In other words, they bring a habeas petition, they can say to a federal district judge, I am not Trende Araba. And a federal district judge would review that, at least to some degree. It sounds like you're not affirmatively endorsing that, but you're not arguing against it. If that is true, that they can do that, how would that work? My understanding is that in some ways it's already working. There are some individualized habeas hearings being held in Texas where the detainees are being held. So can you just help me understand? I think it's a friendly question. So if they can bring a habeas petition, say, I'm not a member of TDA, so you shouldn't remove me under the president's proclamation. How would they bring that habeas claim? What would that look like?
Certainly, Your Honor. So they can bring an individualized habeas claim, and at least some arguments are certainly available in habeas. Ludecky itself reviewed a due process argument in the habeas context. So certainly, at least that is available. The precise contours of that would be resolved by those habeas courts. But to your question of how would this work is how it is working in Texas right now. Courts are deciding that. How it absolutely cannot work is how the district court.
I know that's what you think. I'm not saying I disagree with you.
Oh, that's what you think.
So let's say they're being held in a detention center in Texas, and they want to file a habeas petition to stop their removal under the proclamation. Would they have access to a court to do that?
They would certainly have access to a court to do so, and many have done so.
And that's important too, what you just said. Many have done so. These hearings, these habeas hearings are ongoing now, individualized habeas hearings in Texas.
That's correct, Your Honor.
Okay.
For the people that were on the airplanes last weekend, given an opportunity to file habeas?
Well, Your Honor, that we are here on a case in which the 5 individual plaintiffs were able to get in court and were able to get a TRO, and therefore were not on planes. And so they.
But one or so was on planes and got removed.
What's that? Of the 5 named plaintiffs? That's not my understanding, Your Honor. All 5, the government has represented that those 5 were not placed on planes, that the 5 that had the benefit, the individual plaintiffs that had the benefit of the first TRO who were able to get in court in time.
In this process that I'm describing, the 5 named plaintiffs here who did file in this court before they were removed from the country could have, you tell me if this is wrong, could have just as easily filed in a Texas district court a habeas petition in the district where they're being held.
Absolutely, Your Honor, and notably in the complaint that was filed in this case.
I'm just pausing for a second, everybody. I think what the judges are trying to do here is get this attorney to recognize the jurisdiction that the courts have. Because he started this by saying you have no jurisdiction to make any rulings. And the judges are saying, well, what about all this habeas stuff? What about all the court proceedings that we're talking about? So you're saying, you're agreeing that they have jurisdiction, but you just said they didn't.
It joins defendants from removing them under the Alien Enemy Act. And those are ongoing in Texas. Some of those are ongoing.
Absolutely, Your Honor.
Yes, is the government detaining anyone solely on the basis of the Alien Enemy Act?
Your Honor, I would have to check that specifically. Almost everyone is being detained additionally under Title VIII. So I'm not sure if there are any specific AEA only detentions. Certainly, but the challenge has been brought to that.
I'd be curious to know if you can find out and if it wouldn't reveal, something too sensitive to reveal. If there's anyone being detained solely on the basis of the alien.
Your Honor, we're certainly happy to track that down and provide that information to the court.
So the TRO,
And it seems like the relevant things were people being removed solely, not detained, but removed solely based on the proclamation. It seemed like, and again, you can clarify for me, I'm just looking at a full record here, that proclamation was signed and people were getting put on planes
Right.
immediately without even notice as to the basis, let alone an opportunity to file suit. And so with those removals, I think there was one airplane that you said that was, people were removed on other grounds. But there were two where the government hasn't argued that. Am I recalling the record correctly?
Your Honor, I believe so. I mean, the fact.
Two planes worth of people removed under the AEA, not under withholding of removal process, or removal, the ordinary INA removal.
The Title VIII process. Yes, Your Honor. But I think the fact is that 5 individual plaintiffs were able to march into court, file habeas, actually get relief, admittedly on non-habeas grounds. And the fact that opportunity.
Without the government, I mean, that was a super fast order that was done, as you know. I mean, the government was called and notified, and then a hearing that afternoon. But that's one of the reasons there's all these separate disputes in district court compliance, because planes were already loaded and taken off. And those folks did not have notice or an opportunity to challenge their status at all. And that's why there's had to be a class certification to slow things down until we have an opportunity for due process.
Your Honor, I think this court's decision in IM versus CBP is instructive on this.
Am I wrong about anything I just said, actually?
Your Honor, I think it's incorrect that they couldn't have gone into court as the 5 individual plaintiffs.
No, but
also
the point here was that there were plane loads of people. I mean, it's a class action. There were plane loads of people. There were no procedures in place to notify people. Nazis got better treatment under the Alien Enemy Act than has happened here, where the proclamation required the promulgation of regulations, and they had hearing boards before people were removed.
That's a
And
big
yet
one.
here, there's nothing in there about hearing boards. There's no regulations.
That's a big one.
And nothing was adopted by the agency officials that were administering this. People weren't given notice. They weren't told where they were going. And they were given, those people on those planes on that Saturday had no opportunity to file habeas or any type of action to challenge the removal under the AEA. And like you've agreed that 2 of those airplanes, people were removed under the AEA. What's factually wrong about what I said?
Well, Your Honor, we certainly dispute the Nazi analogy, but more importantly, the fact is that individual plaintiffs were able to file habeas in time in order to secure relief.
Wait,
And
what
what this court-
individual plaintiffs were?
The 5 individual plaintiffs that
That's not my question. My question is there were a lot more people. They wanted to bring a class action. They had to have some named plaintiffs. So 5 people filing habeas doesn't help everybody else on 2 airplane loads. Correct? And my question to you is, and you said those 5 didn't get put on the airplanes. So as to the 2 airplanes that I think you just agreed involved removals solely on AEA grounds, on Saturday, the very short time of the proclamation's publication, had no opportunity to file for habeas or even notice as to the grounds on which they were being removed. Am I wrong about that?
I think so, Your Honor. The fact that 5 individual plaintiffs did file habeas
Oh my
and did get
gosh.
relief indicates that they could.
I don't think you're answering my question.
Nope, he's
My
not.
question is not as to the 5 plaintiffs. How much time, I want you to think of 5 other people on the first airplane. How much time when were they given notice that they were being removed under the AEA on the grounds that they were members of Trinity ARCA? And how much time were they given between that notice and being put on the airplane that Saturday, right after the proclamation was signed?
He's refusing to give that information at district court.
Your Honor, those facts are not in the record, and I don't know all of them offhand, but I think.
Okay, so
It's a-
what do you think?
But I think the fact that 5 individuals were able to do so
No, they
indicates
got-
that others
they're
could
lucky.
have. Well,
They filed suit before the proclamation was even published. I've asked you after the proclamation was published. And I assume these habeas actions that you're talking about, and correct me if I'm wrong, that are now being filed in Texas, have been filed since there's been a stay.
But Your Honor, I'm talking about
Right.
the 5 individual plaintiffs in this case.
That's not my question.
I
The
understand.
question here is, if someone thinks there was a meaningful opportunity,
Wow.
notice an opportunity to file for habeas for the people on those 2 airplanes, they're not these 5 airplanes. Because they filed before the proclamation was even published.
Wow.
There was no opportunity for those folks to file habeas. Then that's the issue for the TRO. Freeze things in place
Yep.
so that compliance with due process can occur.
But Your Honor, as to due process
You
claim,
haven't disagreed with any of my facts about there wasn't time for the people on those 2 airplanes.
That's
Yeah.
huge.
Your
I'll
Honor,
point one at a time. Were they given notice before being put on the airplane that they were being removed because they were members of Tren-Duragua pursuant to the President's proclamation under the AEA?
Your Honor, I don't think that is in the record.
You can't speak for the government with knowledge about that.
Your Honor, my understanding on public news reports is that they had some sort of notice. I don't know the specific contours of that, but again, our position is that
So there's no record that they were given notice. And then how much time was there between the President's signing of the proclamation
Allegedly.
first for those 2 planes taking off?
Your Honor, that's not in the record. I don't know that
But
specific.
you had the times of those planes
Oh, wait,
down pretty clearly, and we know what time the President's proclamation was published.
Your Honor, the record has what times that they had departed before the 7:25 p.m.
That must be findable. What time the planes took off.
Your Honor, it's that is currently, the government is currently engaged in evaluating if any of that can be disclosed.
He doesn't want to tell them.
If you can't tell what time they took off.
We have told what time what their status as of when the 7:25 p.m. minute order issued, and I'm not authorized to discuss any more operational details
Is
of that.
the government aware of how long it takes to fly from wherever this airport is in Texas to El Salvador generally?
Ooh, she's
Your
getting
Honor, I
him.
don't know that off the top of my head.
That can be found out pretty easily.
She's getting him.
It just feels like there was no time. And the habeas cases you're talking about now were only able to be filed because the district court froze things.
Well, Your Honor,
Right.
this case itself was originally filed as a
Are there
habeas action.
other habeas cases that you mentioned filed in Texas? When were they filed?
Your Honor, I believe at least one of them was filed, but before the plaintiffs indicated that they thought the plane had taken off. That I can track down, but that's my recollection.
The other ones have all been because there's a stay in place.
What's that? You know, I don't know the precise status of every single one of those individual habeas actions. That's a very
They
fast.
could have been filed before the President's proclamation was made public. And before someone was told that they were being subject to it.
Ooh, she is shredding him.
Your Honor, again, I just
Because it wouldn't be a right claim.
Your Honor, we're here because 5 individual plaintiffs filed a
Oh my
complaint that
gosh.
clearly included habeas claims, as Judge Walker indicated, and here we are hearing that very claim. And here's what this court said.
Case law's not going to help you,
and,
dumbass. Just use
excuse me.
common sense.
In I Am versus CPP, I Am contends that a removed alien may file a habeas petition if extreme circumstances prevented him from filing while he was in custody. We disagree. Lower courts are created by Congress and have
Wow.
only the jurisdiction Congress grants, no more, no less.
He's going back
And,
into
Your Honor
jurisdiction.
indicated that you thought that this was a matter of due process, but I think that's very useful here because the Supreme Court and this court have confronted due process claims challenging the invocation of the AEA. And, here's what Supreme Court said in Ludecky. It said, the act is almost as old as the Constitution, and it would savor of doctrinaire audacity now to find the statute offensive to some emanation of the Bill of Rights, which obviously includes the...
I'm saying the whole statute's unconstitutional. No one's saying the Alien Enemies Act is, well, maybe they'll tell me they're saying that, but the entire Alien Enemies Act is unconstitutional. That has been decided. The question is whether a particular proclamation and its implementation
Yeah.
is constitutional. This happens all the time.
Yep.
Statutes are constitutional, but how they're implemented in a particular case
Exactly.
is not. That's all we're talking about.
He's too far into the
And
weeds.
in Ludecky and in Clark, Clark was a case like this one. It wasn't a habeas, sorry. I used a shorter name for the case in this court, Clark. It was 159 people and an organization who represented their interests who filed suit. And we recognized there that you could have a challenge to whether you qualify under the proclamation, right?
Your Honor, I don't
And
think.
that's the issue here, is whether there's a process.
I agree that that's how the district court saw it, but there were due process arguments raised in those cases as well. And, you know, this court said that if there was the slightest question in the minds of the authors of the Constitution or contemporaries concerning the constitutionality of the Alien Enemies Act,
We're
it
not
would
talking
appear.
about that.
None did.
Yeah, that's the constitutionality of the act.
Yep.
You just finished the sentence for me.
Yeah, we're not
My
talking about it.
question, and I think what district court here hasn't called into question the constitutionality of the Alien Enemies Act. It's
Right.
been upheld, as you said, it's a part of the war power.
Right.
But so that's not the question here. The
Nope.
question is whether the implementation of this proclamation without any process to determine whether people qualify
Right.
under it. I mean, if the government says we don't have to give process for that, then y'all could have put me up on Saturday and thrown me on a plane,
That's right. That's right.
thinking I'm a member of Tenduragua.
That's
and giving me
right.
no chance to protest it and
This is
say
this is what
somehow it's
happens
a violation of presidential war powers.
when you
And
try
you
to
say,
flood the
"Excuse me,
zone.
no, I'm not. I'd like a hearing." You wouldn't say that.
Your Honor, obviously nothing of the sort is presented by the record here. I think what
But we don't have any record on whether these individuals are members of Tenduragua or victims
Yeah,
of Tenduragua.
that's
Your Honor,
right.
as you've characterized it, what that sounds like to me is an argument that the AEA is unconstitutional because it doesn't provide
Nope.
for free
Not
deprivation.
an argument about the statute. I'm going to say this, and I don't know how to say it any more clearly. My questions are about the implementation of a particular proclamation under the statute. That is
Yep.
not an argument. And quite frankly, the statute provides that there will be regulations issued. And regulations to determine someone's status have happened every other time the statute's been used. So this isn't about the statute being unconstitutional. It's whether implementation of it under this proclamation
Right.
is unconstitutional. And not even, is it unconstitutional? Is there a likelihood of showing that there's a constitutional problem here because of the lack?
Of due
due
process.
process.
Yes.
We're not even deciding the merits. So please do not attribute to me that I'm saying the statute's unconstitutional. You and I agree that that has been answered. An implementation of a proclamation is a completely different question.
She's
we agree on
trying to
that?
keep her temper.
Your Honor,
You won't agree, I mean, maybe that it's constitutional problem, but you agree that it's a separate question whether the implementation of something under a lawful statute is constitutional.
Your Honor, certainly at that level of abstraction, I agree with you. I
Okay.
see that.
Build down exactly what this case is. That's not abstract.
Well, Your Honor, where I disagree is that, as Your Honor identified, the AEA requires the issuance of regulations. It does not require the provision of pre-deprivation process. And so I think that would be an argument that under the due process clause, the failure to provide of the AEA itself to mandate pre-deprivation hearings
No.
is unconstitutional. And I think that is the sort of challenge that was considered and rejected.
When was were other usages of
No.
the AEA?
What? What's that guy
done
talking
when people
about?
were summarily removed without it being processed? Can you show me an example in history when the AEA was used that way?
Yeah.
Yes, Your Honor. So in Ludecky, for example, there was requirements in the implementing regulations that that an alien had to be dangerous before that they would be removed, and there was part of the challenge was that that person was not dangerous, and wanted to challenge the Attorney General's determination that he was, and what the Supreme Court said. Is that President Truman, provided for the removal of such aliens as were deemed by the Attorney General to be dangerous, that such a finding at the President's behalf was likewise not to be subjected to the scrutiny of.
Different question.
Whoo.
Footnote 5. The order recited that the petitioner was deemed dangerous on the basis of evidence adduced at hearings before the Alien Enemy Hearing Board.
Ooh.
That's what I'm talking about.
Dude, you gotta read better, man. You dumbass.
They had a process there for the decision. Question whether a court can review whether a secretary properly deemed someone dangerous. That's what they said. That's committed to the discretion of the secretary whether someone's deemed dangerous.
That's a different question.
But there was hearings and there was process. I
Yeah.
asked you when they haven't had process.
Yeah, when?
Your Honor, I guess then that points to me that this conversation has been very much about due process, but even as the 37-page, opinion that issued this morning, it seems to sound in due process, but doesn't hold, make a holding based in due process.
That's
and
this
so
one.
that alone,
Well, it says it's limits, it's not holding because it's a TRO. It says
Right.
it's limiting its likelihood of success analysis.
You're too far,
for
dude.
that question. And then to get, if you want to respond to that, because I wanted to get to this question of whether it can only go through habeas, but I wanted to let you.
Your Honor, so, we think that the rationale has been swapped out at the last minute, less than 4 hours before oral argument. We
Oh,
think that's
suck it
procedurally
up, you
proper,
whiny
potentially
baby.
jurisdictionally problematic, where the ordinary rules of jurisdiction do not permit district courts to present this court with a moving target on which
He's
appellate
just
review. And I
pissing
think
these
that's
judges
exactly what
off.
we have here.
Another procedural problem here is that you never sought a stay from the district court.
Boom.
That's correct, Your Honor. This is obviously an
You've
issue.
had plenty of time.
Boom.
A week, more than a week. You've never sought a stay
Yeah.
from the district court first, which
Ooh.
our precedent require.
No, Your Honor,
Oh.
certainly that is a general thing. This case is absolutely extraordinary that we moved within mere hours for this court. It obviously was not possible to exhaust before the district court in that time.
Before the court, I don't mean you personally, government was before the court Saturday afternoon in person.
Yeah.
On the TRO issue, right? There was a
Wow.
government attorney, it was you or someone else, but there was a government attorney before the court Saturday afternoon when the operative TRO now was.
Could have asked for a
correct?
stay. Wow.
That's correct, Your Honor, although
An attorney have said when the TRO was entered, we request a stay. So
Yeah.
we can seek relief from the Court of Appeals.
Woo.
Did they have time to do that at that hearing?
Oh, man.
I suppose so, Your Honor, although
Seek a stay.
Your Honor, a couple things let me say about that. First of all, that TRO, it was scheduled as a hearing for class certification. That the government was surprised to discover, and I was personally just surprised to discover that the TRO merits would be discussed. The hearing was only set for class certification, and on that question of class certification, the government was not permitted to file even a single sentence of written briefing in opposition before we were hauled into court on a Saturday at 5 p.m. and a nationwide class action class was
Because you're
certified.
shipping people
And then,
to El
in that
Salvador.
posture, we were then surprised to discover that, notwithstanding the fact that the order,
Oh my
sorry,
gosh.
that the notice was for a hearing on class certification, that in fact a second TRO would be the merits
3
would be
planes.
considered.
El
That was
Salvador.
presented there.
3
we
planes,
certainly
dude.
believe that it wasn't.
I don't understand how that means you didn't have time that afternoon.
She's
or
calling him
Sunday,
out
or
on
Monday,
it.
or
Oh, I
Tuesday, or
love
Wednesday,
it.
or Thursday, or Friday, or Saturday, or Sunday, or this morning.
Your
Ask for a stay from the district.
He
court.
wants due process.
time,
Yes.
correct?
Your Honor,
We had time, yes or no?
Ooh.
we've had time. It's clear that we went to this court. Your Honor, certainly too, this is not, I believe, an issue, the FRAP 8 compliance that plaintiffs have raised. So it's by itself, it may have been forfeited because that is not.
He's
an
stumbling,
argument
yeah.
that I believe that plaintiffs have raised. But before that, we had already sought a first stay.
You admitted it right in your filings with us.
Certainly
You teed it
did.
up.
Yeah.
You didn't have to raise it, you teed it up in your
Yeah.
filings, that
Yep.
you didn't do this. You know how often the government has asked this court to dismiss the applications because someone didn't first ask it before?
Your Honor,
Ooh, how many?
Your Honor, I
How many,
acknowledge that as
Judge?
a common course in cases, there is nothing remotely ordinary about this case.
No,
It's
tell
certainly
me.
not.
But what is very ordinary is that you have plenty of time to ask.
Oh, man. We're going to be left hanging on that
You
one.
normally didn't, but you had the time to type into your briefs here. We didn't ask the district court for a stay.
Your Honor, because we thought, frankly, candidly, we hope this court might act more quickly, and we therefore
Ooh.
wanted to get relief as soon as possible, given the stakes of the issues presented.
I guess you thought with the stakes that you would want to cross your procedural T's and not the I's.
Whoa.
Given the extraordinary importance of this case,
Whoa,
and the fact that
dude.
it's presented,
Case exception to, I mean, it seems to me all the more reason to ask the district court for a stay if it's important.
Oh.
Does the government have the view that we should adopt
Wow.
as a ruling in this court that when it's extraordinarily important, but there's still plenty of time.
He didn't file what he needed to file. She said
Right.
technically they could
First, or from an agency first?
dismiss the case.
Your Honor, we disagree that there was plenty of time, and we went to this court.
Yeah, more than a week.
More than a week. You hear that voice tone?
Your Honor,
Sometimes.
Your Honor, to the extent that this court believes that exhaustion is important, we're happy to do so before the district court. We expect that we would get an almost instantaneous denial. If that's something that is holding up relief in this case, that's something we're happy to do.
Oh, he's trying to gain power back.
I had questions about your argument that this has to be done, that this relief has to be sought through habeas corpus.
Yes, Your Honor.
There are a lot of cases.
She's like, there's nothing left on that bone. Let's move to the next one.
Recognizing, and again, Clark is the chief one right under the Alien Enemies Act. That when someone is bringing a procedural challenge,
You might be right, John.
that two things. A procedural challenge, you don't have to go through the ordinary individualized decision making that you do for immigration challenges, removal challenges. But you can have class actions that bring challenges to the procedures by which removals are being implemented. And that's not a habeas claim, because it's a challenge to procedures. And married to that is that not one of these plaintiffs, or as best we can tell, people in the class, is asking to be released
Yes, Isabel.
from custody. And the Supreme Court has said time and again that when you aren't being asked to release from custody, like they want to stay in the U.S. custody, no
Yep.
one's challenging the right of the government to detain them.
That's why there's a
But
habeas
is
question.
not the right vehicle.
Exactly. Yes.
Gaussium, you've got
Woo!
it's not the right vehicle.
Yay!
And in Clark, we allowed a lawsuit by an organization and 159 parties challenging application of the Alien Enemies Act.
Yes. She said it
Your Honor,
out
I disagree with that
loud.
for three reasons. First of all, the procedural right here that the district court derived in its order this morning essentially comes out of a string side of habeas cases. And so
So
the
what?
right that the district court has defined here is clearly, to the extent that it exists, a habeas right.
No,
No.
it's a right to have procedures and opportunity in place, notice and opportunity in place across the board for everyone who's being removed.
Habeas is about custody.
Detained, removed under the Alien Enemies Act.
Oh, that's such a
You're-
huge
you're-
point.
Your Honor, I think two more responses to that. One is that the right at issue is being derived from habeas, and that's very important because it means that APA jurisdiction isn't available.
I don't know
Here's
that's
how this
true.
court addressed a very similar case in LeBeau versus Christopher.
I don't think
It
that's
said
true.
that the key to plaintiff's inability to pursue a suit here is jurisdictional and rests merely on the availability, not the actual seeking of habeas relief elsewhere. This court then further went on to explain that, quote, the availability of a habeas remedy in another district ousted us of jurisdiction over the alien's effort to pose a constitutional attack to his pending deportation. End
He
quote.
cited that
And so what
same
I think you
thing
have here
in his
is
hearing
the
with the other
district
judge.
court found a right derived from habeas cases, and the fact that it sounds at
I don't think
habeas
that's true.
means under LeBeau versus Christopher, it has to be.
I'm very confused.
Me too.
I'm very confused because we've got plenty of cases, the Supreme Court's got plenty of cases that say when you're not asking for release from custody. Munaf was someone who said, I'm happy to be in the U.S. custody. Please don't release me to Iraqi custody. And that's right. And that sounds very similar to here. We are not, I'm not happy, but we're not disputing the right of the U.S. to detain them.
Yes.
What they are disputing and challenging is the capacity of the U.S. government to release them to Salvadorian jails
Yeah.
without any advance notice and due process.
It's just that
Doesn't
simple.
even qualify under the proclamation. That's not release. And we have said time and again, and the Supreme Court has told us, which is much more important, that's not habeas.
Well, they think it's more
Whether
important.
it's arising in an immigration context, a war powers context, like the war in Iraq,
Yeah.
it's not habeas.
That's
Not
right.
addressed through the APA.
Your Honor, I disagree with that. I agree that Munaf is an instructive case, but I think it cuts the other way. Here's how the Supreme Court characterized it, and
Oh,
this is how you were characterized as well. It's like, here the last thing petitioners want is
he's
simple
just
relief.
reading quotes
They essentially want
to
to
get out of it.
But nonetheless, I believe it was part 2 or part 3 of the Supreme Court decision in Munaf held that habeas was available, and then in part 4 it held that habeas petition failed on the merits.
That
The first
doesn't even
issue
mean
presented
anything.
was whether or not you could bring habeas in such a circumstance.
Word
and the answer to
salad.
that was yes.
Nope.
And
And the Supreme Court held it again on Versavia. Sorry if I'm saying it right. Versavia, right? Filed habeas petitions in an effort to block their transfer to Iraqi authorities, rejecting this use of habeas.
Yes.
Rejected it.
they rejected it on the merits, but they didn't say that habeas wasn't available. And I think Therasighium is a different
My God,
case.
he's
That
telling the
actually was
judge.
a challenge to the procedures, but that doesn't sound in habeas. But here it does sound in core habeas, and let me explain
No,
why.
it's not. It's a procedure. You don't have any procedure, at least as of Saturday when the TRO is issued.
Yep. Yep.
Time the TRO is issued. Or about the second one, 'cause I guess. Sort of the second one.
I'm throwing popcorn in my
Time it issued,
mind.
There was no procedure in place, no advance notice sufficient to allow anyone to seek habeas.
That's-
And there was nothing in the proclamation or in regulations or processes, formal regulations, but processes adopted by those implementing the proclamation to give any such process.
That's right.
That's the argument. That's the issue.
it's
And
just
was
that
not
simple.
released. That is request for injunctive and declaratory relief due to failed procedures
Right.
that Supreme Court said time and again do not constitute, cannot be brought in habeas because you don't want release.
It's the procedures that
Your Honor, I
tangled up
disagree
this
with that on a
whole
number of fronts. First of all,
administration.
again, on page 41 of the Saturday transcript, it's very clear that the basis of the TRO on appeal here was a frontal assault on the president's determinations that various statutory preconditions of the ADA.
Okay, but if we don't read it that way, we read it as also being grounded in these claims for a process. And that's why they came in so fast. So we get away from those issues. They want declaration or injunction against TRO to start with. Declaratory or injunctive relief against removal
Your Honor, the fact
and a failure to adhere to due process by those implementing the proclamation.
Oh my gosh.
Your Honor, I disagree for 2 reasons. I think, first of all, their
Oh,
complaint still
man.
clearly includes those facial attacks on the sufficiency of the statutory preconditions. As long as those are in there, those are an attack on the government's ability to exercise a scintilla of custodial authority over the bodies of plaintiffs
Oh
in order
man.
to either detain them or to remove them. And so as long as those are in the complaints, those sound in core habeas, it cannot be brought here and would require transfer to another district or dismissal. But second, I think that the procedural one still challenges fundamentally in core habeas. It says you may not do anything to me under the AEA until you satisfy these preconditions. You are utterly without power to do so. I mean, that
Wow.
is the same sort of core habeas as asserting that a conviction is wrong because procedural requirements in a trial were not followed.
No, I don't think that's the same at all, because people don't go through a trial in this country without getting the gold standard of due process.
That's right.
And that was not happening here.
That's right.
I think that's a false equation.
It is.
The problem here is
This attorney is the problem.
that they are challenging implementation of the proclamation in a way that never gave anyone a chance to say, I'm not covered.
Right.
And if your argument is he didn't have to do that, it's an intrusion on the president's war powers, the courts are paralyzed to do anything, then that's a misreading of precedent. It's a misreading of the text of
Yes.
the Alien Enemies Act.
Yes.
And that can't be an unlawful intrusion on the president's powers. It just can't.
It just
The
can't.
president has to comply with the Constitution and laws like everybody else.
That's right.
On that, we certainly agree, Your Honor. I think that what
Do
has
we?
occurred here
Do we
is
though?
that, aside from the shifting injunction issue, is that the district court has derived a right from habeas and then used that to create a non-habeas right.
Derived from habeas.
The pre-deprivation thing, the right that he
Oh my
found in his
gosh.
his morning's order comes entirely out of habeas cases, and that's how it has to be served.
All right, so your theory is that they don't
Ugh.
get to challenge it until they're in the Salvadorian jail?
I'm yawning
You
with
know, the
disgust, everyone.
pre-deprivation? I don't understand the pre-deprivation, they're already in detention.
Yeah.
So if I'm understanding you right, are you saying that they don't have a right until they're removed from the United States in US custody
Ooh.
to challenge? This isn't an Ken situation. There's nothing like that. They're challenging an immediate removal, not under the Immigration and Nationality Act, but under the AEA without process.
Yeah.
Is your theory is they're supposed to do it from the Salvadorian jail after the fact?
No,
Huh.
Your Honor, that it's that whatever right that there are sound in habeas, much like LeBeau, where
gosh.
the challenge was to a non-Title VIII removal. That sounded in habeas and had to be brought as such, and the availability of habeas meant that the district court was outside of jurisdiction to hear other claims. That same logic means that the TROs issued below are invalid and should be reversed or
The
dissolved.
Supreme Court in McNary versus Haitian Refugee Center, Reno versus Catholic Services said
He's just got no
we don't care
basis.
about jurisdictional limits on claims that are supposed to go through ordinary statutory processes.
He's trying to
like
make a basis.
Title VIII.
And our
So you
system
are
doesn't work that
bringing
way.
a class-wide action for injunctive and declaratory relief about procedural failures. That would seem to fit this case.
Yeah.
Your Honor, we disagree.
Ugh.
I mean, I think to the extent that it's procedural, it sounds in habeas, and hence this class does not operate properly.
Move on.
Not procedure, an individual can't complain about. This is, they needed to do it class-wide because people weren't gonna have the opportunity to file a suit and bring a procedural one. On the individual determination of whether someone's a member of Tender or Wagwa, that's a separate question. But for injunctive and declaratory relief that does not seek release from confinement, Supreme Court has said time and again, that's not habeas.
Nope.
Your Honor, I disagree. And had they brought this case in district court in Texas, they could have raised it as both APA and habeas. They instead elected to choose a different court. And that meant that that came with all the jurisdictional limitations of that particular court.
It's a venue issue for habeas, not jurisdictional. That
Ooh.
doesn't affect the jurisdiction of the district court, that's a venue issue.
Ooh. She's schooling
You're
him.
suing the custodian.
Your Honor, it's not subject matter jurisdiction, but it does go to the authority of the court. And in the Rumsfeld versus Padilla, the
Oh
Supreme
my
Court
gosh.
did say it was jurisdictional, not in the subject matter jurisdiction, but it's not just a mere venue rule. It cuts to the core authority of the court to grant habeas relief.
As long as it can be served with process.
Process.
Right? As long as the defendants can be served with process.
Due
That's
process.
just a venue argument. And an important one, I'm not diminishing that at all,
Yeah.
frequently in farce.
Yeah.
Venue requirement that you sue the right custodian, and that custodian, by definition, in the district where the person's detained.
Your Honor, we certainly agree that it's case dispositive. I think it's not,
my gosh.
venue may undersell how important it is.
Is he
Supreme
arguing
Court has
venue versus
characterized it as jurisdictional in
jurisdiction?
the sense that it goes
Oh my
outright to the
God.
authority of the court and not merely
With an
a
appellate
sort of,
judge? Oh my
you know,
gosh.
steering things to where they might be convenient to be heard. It's something more fundamental.
It
than
seems
that.
sovereign
But
citizen-like,
in any
doesn't
event,
it?
that probably doesn't matter because I think we're agreeing that if venue is improper or for habeas, like the court is just simply out of authority to do it.
True story, VC. Okay. Come on. Come on, judge.
We'll give you a couple minutes to reply.
Thank you, Your Honors.
Mr. Miller.
Okay. Other side. Doesn't really have to say much. Doesn't really have to do too much here.
Good afternoon, Your Honors. Lee Galern from the ACLU for plaintiffs. Time permitting, I want to address why this court, the courts absolutely have jurisdiction to review whether the statutory predicates to the Alien Enemies Act have been met and why they haven't been met here. But I want to put that aside for the moment and sort of jump into the conversation you've been having
Yeah, that's
with the
best.
government. First, I just want to put one thing to bed. The district court has not said anything yet about whether he intends to try and bring people back who are already sent to El Salvador. The district court is very concerned, understandably, that his order was violated, but he is trying to get to the bottom of those facts. He has not made a determination of whether his order was violated, much less what he would do as a remedy, whether he would try and order the individuals back. So I don't think that issue is before this court. I think that's a red herring.
Red herring.
The second thing is that I think the government now, and we in the government have sort of joined issue. At a minimum, it seems like the government is grudgingly admitting that after Ludecky and footnote 17 in particular, that there must be ability to contest whether you fall within the act. And so now I think it's a question of how that's going to go about
Oh, within
happening.
the proclamation, not the act.
I'm sorry?
Within the proclamation.
Well, yes, within the proclamation. And so the district court has said very clearly he wants to figure out how that would work. He's asked both of us, neither us or the government had a clear answer for him at the moment when he asked it, the hearing. He intends to get to the bottom of it. But I think what it means is that even if this TRO is appealable, and we don't think it is, but even if it was, I think it's the easy ground to affirm the TRO is that there was no process. And I want to be very clear about 2 points. One is that the process, to the extent the government says you can have process, that's illusory. People were designated TDA without any advance notice, rushed to planes. We will put into the district court a piece of paper that individuals are getting that specifically says you are not entitled to review. So there is a lot of factual development left to do in the district court. Judge Boasberg is working extremely hard and extremely quickly, but I think this court would want that factual record. And I think that's one of the reasons the TRO is not appealable. This is not. Yes.
Could you have done everything in a Texas district court
Don't
that
cry.
you did?
No, I've got
This district court?
allergies.
Perhaps, Your Honor, but I don't think it was necessary. There's absolutely no question now that the law is that this kind of challenge where you're not seeking release doesn't have to be brought in habeas. It can be
Yes.
brought by APA. It could be brought in habeas, but it doesn't need to be.
That's right.
Well, so I want to get to that in a minute. But I think the common ground that you've just sort of asserted, the government, you said kind of has begrudgingly given, it's really significant common ground that I think has been lost in some of the briefing and some of the transcripts. You could have filed the exact same complaint that you filed here in Texas District. The government is not contesting that
Whew.
each
Sorry, everybody.
could have gone before
Oh, wait.
an
You can't
Article
see me.
3
Never mind.
judge and said, I am not a member of Trinidad Aragua, so I'm not covered by the proclamation, so I can't be removed. And could have done that. I think you would both agree that the plaintiff could have done that with a habeas petition. I know you push back and say it doesn't have to be a habeas petition, but I think you would agree that everything I just said is true and that it could have been done through a habeas petition.
Right.
Is that right?
Well, Your Honor, yeah, I mean, I don't think it's insignificant that it didn't have to be by habeas and that we have to, well, plaintiffs, we can choose our venue, but I want to address your question specifically. We could have filed a class, perhaps, a class habeas, if that's what you mean, but we certainly weren't looking just to get our 5 individuals from being sent to a Salvadoran prison.
Right.
So this would have had to be a class. If the government is suggesting that we could have gone in there for every individual, absolutely not. We did not know it was been designated. This has all been done in secret. The president signed it.
I think you're going beyond what my question was.
Okay, I
And I'm not sure
apologize.
the government would agree that you can certify a class in habeas.
Oh,
I'm not sure I
exactly.
would agree with that either, or is that more of an open question that we would need to look into? But on Saturday, early afternoon, you asked the district court to enjoin the removal of the 5 named plaintiffs. The district court did. A Southern District of Texas court could have done that as well, right?
So, I just want to factually,
Okay.
we filed it at 2 a.m, whether it's Friday night or Saturday morning. The district court in the early morning enjoined the 5 named plaintiffs. The class papers had already been filed with the complaint at 2 a.m, both complaint for declaratory injunctive relief and habeas, with class papers seeking a TRO for the class. The district court then held a hearing at 5 p.m. to decide whether his TRO was going to apply to the whole class. Absent a class TRO, we would have had far more people sitting in a Salvadoran prison.
But my question is not about what the district, my question for now is not about what the district court did, it's just about whether everything the district court did, which you just described, and I was off by a few hours, but it was Saturday.
Right.
It was a long Saturday. Everything that happened that the district court did, a Southern District of Texas district court could have done.
Assuming they would do it as a class,
So this,
yes.
So I think that nicely tees up where the real dispute is, because you're not saying you couldn't have done all this in Texas, and the government is saying, A, this has to be habeas, and habeas has to be in the district where the detainee is detained, and that would be Texas. So I know you disagree with both of those things, but I think the government, I think there's some common ground.
I don't
There's
care.
common ground now that there has to be process, although I still see the government accepting it grudgingly, because this whole pre-deprivation thing, we were talking about people being sent to El Salvador, one of the worst prisons in the world, incommunicado. They're essentially being disappeared. President of El Salvador has now said maybe they're going to spend the rest of their
We've
lives
detected
there.
audio in
The
your
government has
stream
provided
belonging to someone
zero
else. Your stream
ability
may be
to bring
temporarily
habeas.
blocked.
It would have had to have been
Please
done by a
ensure the
class. If it's
content
government saying,
owner.
going forward, we'll give you process. I have not
What?
heard one word about them giving us
At this
advance
point,
notice.
At this point, everyone who's detained can bring, would you say that at this point, everyone who's detained can bring a habeas?
Please ensure the content
Because
owner.
of the TRO by
Okay.
Boasberg only. And that is even assuming.
All right,
I
well,
don't
we
think
should be
this is
okay.
true, that everyone has been clearly designated, that we know
They're
exactly.
here, me
what
and the
government
court.
thinks falls under the proclamation. And therefore, if they didn't file a habeas right away, they could be put on a plane. And so I certainly don't think this is the way it would go about with individual habeases, and
If the TRO were lifted, it wouldn't be a meaningful way to bring habeas.
I think the government is going to put people back on a plane immediately, just as they did. The whole thing has played out in secret. The president is supposed to make a public proclamation. He signed it on March 14th. It wasn't published till the afternoon of March 15th. People were already being lined up to be brought to planes. So I think we're dealing with something that is illusory, and that's even if we accept that habeas can be brought. But I
mean, we know it can be brought because you brought it. You filed a habeas.
it could be brought by habeas, but it doesn't have to be. And I think
So
we are
let's go to that, whether it has to be.
right.
And I think perhaps reasonable people can
Oh,
disagree.
content owner.
I think it's hard to get around
Post
review.
it.
The district court addressed it today.
I'm sorry, hard to.
Review, I maybe pronounce
Yeah.
that.
So that
See.
yeah, sure. I'm sorry.
Because of course the plaintiff's focus is not explicitly on their present custody. That's very similar to this case where you're saying, we're not asking to be let out of detention. We're just saying don't transfer us to one of these other countries. Because of course the plaintiff's focus is not explicitly on their present custody. They claim the nature of the relief requested is different here since they have not formally sought a release from custody as in the habeas action. But, the court goes on, we have rejected precisely such effort.
Entertainment purposes only.
Reducing effect of habeas jurisdiction.
Here you go. Let's see.
So I think that's a tough precedent for you where,
Here, maybe we can we see it?
I understand it, was about to be extradited to Canada, didn't want to be extradited to Canada, could have filed in Illinois where he was detained. Actually did file a habeas petition there. Filed in DDC, and our court said, no, you can't bring this suit in DDC. You have to bring a habeas suit in Illinois to challenge not your detention, your transfer to Canada.
Yeah, Your Honor, a few things about LeBeau that I want to sort of broaden it. LeBeau is an extradition case. The extradition has for 225 years had its own case law, but I think the key in LeBeau that the court understood was that they were in fact seeking release through their other habeas. And so it seemed a little bit like they were trying to circumvent habeas. I think that's why it's different. But the case law is voluminous that you don't have to bring a habeas unless it's a core habeas challenge to release. And I just want to touch on Thuraisingham for a second, that Judge Millett brought up. Thuraisingham, the government walked into the Supreme Court and said the only time habeas can be used is when you're seeking release from detention. You can't challenge your removal. That was ultimately what the Supreme Court accepted. That was the holding. That's on top of case after case after case saying, if you're not seeking release, and I want to be 100% clear, no class member is seeking release. Judge Boasberg was absolutely clear that his order will not stop anybody from being prosecuted, anybody from being detained, allowing anybody to be released, allowing anybody.
There no, and I don't know the answer to this question. I tried to ask the government,
Yeah.
Maybe they didn't know yet. You may not know either. I suspect you haven't talked individually with every one of your class members. But do you know if anyone is currently being detained under the Alien Enemies Act proclamation and not being detained under any other legal framework?
I don't know the answer to that. I suspect that most people, maybe all of them, are being detained under the immigration laws because they were in proceedings. I mean, the government is using the act to try and short circuit the immigration proceedings. And so I think what they have done is pull people out of proceedings and put them on the plane to El Salvador. So
Your original complaint mentioned apprehension and removal, and you wanted to enjoin both. I understand the district court did not did not accept your invitation to enjoin apprehension, but that does suggest that you were worried there would be some class members currently at large in the country who might be apprehended under this AEA authority.
So Your Honor, I think to the extent that that language is in there, it may be inartful, but we're 100% clear with Judge Boasberg, and he has been 100% clear. You're absolutely not trying to get anybody out of detention, stop anybody's removal, stop anybody's prosecution. And I think that goes to the larger point. This is a very specific statute, a wartime statute dealing with a very specific problem. It does not bar any other authority for prosecuting or removing these individuals, much less have to do with anything about stopping ships in China.
Can I ask you about Munaf v. Garin? Because I do understand how you can read it to the government here and you can read it to help you here. I think the government is saying the first thing the Supreme Court held there was there is habeas jurisdiction. This is someone who wasn't objecting to being held, but was objecting to being transferred.
Right.
U.S. custody in Iraq, the Iraqi government in Iraq, and said don't transfer to the Iraqi government. And the first thing the Supreme Court held was that there is habeas jurisdiction, not because he was an American citizen. And then said, in your habeas cause of action, you lose on the merits, right? Because we're going to respect the Iraq's kind of what they said is
Interesting.
Iraq's exclusive jurisdiction to punish offenses against the laws committed within its borders. So we have habeas jurisdiction, and habeas is your cause of action. But with that cause of action, you lose on the merits because of Iraq's exclusive jurisdiction to punish offenses against its laws committed within its borders. And if that's how it's read, it seems like Munaf is a pretty good precedent for the government saying, look, if you want to challenge your transfer from U.S. custody to another nation's custody, your cause of action is habeas.
Well, I think two things about it, Your Honor. One is Munaf said you could do habeas. It didn't say you must habeas. And I think that's the difference in these core habeas cases. Whether you could bring it in habeas, you often can bring it in habeas, but then whether you must bring it in habeas. So we understand the Chief Justice to be saying in that case, I think it was fairly clear, the last thing you want is simple release.
Right.
And so I think that's why Munaf doesn't answer the question. And Thuraisingham, of course, is the most recent precedent from the Supreme Court.
on the not having to bring it as habeas, the district court understands your cause of action to be an APA cause of action. I think the government says this is a presidential proclamation. It's different than an agency proclamation. I think last time I was on a panel and you were the attorney, it was an agency proclamation. And you can bring it, we see every day in this court challenges to agency orders under the APA. But if there's a challenge to a presidential order, the APA is not typically the vehicle for that. And Franklin v. Massachusetts says, at least as a general matter, it can't be. I think what you'll say is, at least on the individualized determinations of whether the class members are part of Tren de Aragua, you're going to use the APA to challenge decisions that are being made by lower level officials. To me, that, if true, just indicates that there's not the type of commonality for a class that you need in order to certify.
Right, Your Honor, so a couple of things. One is that we cited multiple cases that say even where there's a presidential proclamation, you can challenge its implementation by the agency. But to your common question, our common questions are obviously first whether the AEA can be used at all against a non-foreign government. But the second question is, are they entitled to process? So at some point, if there's individual determinations about whether you fall within the proclamation, those obviously will be all common. But the initial question that we're fighting with the government about, and they're still, I think, grudgingly only conceding it, is whether they're entitled to some process. They clearly have not been given process, but for this action, I don't think the government would be conceding what it had to concede.
What's the status of the habeas petitions in Texas, the ones that have been filed and they're ongoing?
Yeah, that's a good question, Your Honor. We've been trying at council table to find out a little bit about where they are. I think they're generally on hold. Those individuals, there were a few habeas petitions, very few people who happen to sort of guess that maybe their person is going to be designated. But for the vast majority of people, they haven't been designated. I wanted to also clear up one point of confusion. The government keeps reading from the transcript at page 41 that the judge's initial TRO, I mean, the judge has obviously made clear this morning what his TRO is principally based on. But the judge's hearing transcript on Saturday night was very clear that he was also talking about process. And that's at pages 29 and 30, starting at line 25, Your Honor, where he was very specifically talking about process. And footnote 17 in Ludecky that said you have to be able to contest whether you fall within the proclamation. Yeah, no, I'm sorry.
I want to ask about, I guess this goes to some degree, I think it goes to the irreparable harm the government asserts.
Right.
And to some degree to maybe larger issues. And so the question I'm going to ask you is going to sound like I have some skepticism about what the district court did on Saturday. I want to preface that by saying we've had a week to look at this issue, and it's been hard. And the district court only had a day.
Right.
About a decade ago, one member of this court, long before I was on it, talked about district judges having to deal with Guantanamo issues. So they were difficult and intricate and complicated and novel. And he said, even when this court might disagree with the district court decision, that disagreement is with respect for the dedicated work of the district court. These matters. That said, I'm wondering if you can point me to a district court TRO or injunction that survived appeal, that stopped an ongoing, partially overseas national security operation in the way that this, at the time at least, did order planes to take foreigners from international waters to the United States.
That's too far.
Your Honor, so
That's too far,
to
dude.
start with, the order about him bringing people back, potentially bringing people back, is not for you. And I think there's a lot of factual development.
Yeah.
And I don't know how much
That's
this
outside
court
of your
is aware,
scope.
but there have been emergency proceedings almost every day, and I think the district court has not been pleased with how the lack of forthcoming attempt.
I just that though.
Yeah, and so with that,
there's this declaration by, it says that he's been at the State Department since 1971.
how is that?
54 years ago. My
What?
math is right. It's quite That's quite a lot of experience
What?
at the State Department. Now he's a career State Department official, head of the Western Hemisphere's Affairs Bureau. He says that this TRO is, quote, harming the foreign policy of the United States.
What the H is he
Comes after,
talking
quote,
about?
intensive and delicate negotiations with El Salvador and the Maduro regime.
What?
There's the possibility that those governments will change their minds. It gives them leverage for renegotiation.
What?
And he warns, quote, these harms could arise even in the short term.
54 years.
I mean, those concerns are ongoing.
What are
I
you
understand
talking
that
about?
there are no longer planes in the air that are being ordered
Right.
to return to the United States with foreigners that the executive branch doesn't think should be in the United States.
What?
I guess just maybe from a 10,000 foot perspective, I thought about when Justice Douglas enjoined the bombing of Cambodia.
Ugh.
That didn't go very well. The Supreme Court reversed him in about 6 hours.
That didn't go very well.
I found a couple other injunctions that are somewhat analogous, but they didn't survive appellate review either. Can you,
What?
standing here, give us an example of a district court injunction that enjoined national security operation partially overseas
Isabel.
that survived appellate review?
Well, Your Honor, I want to push back on the overseas part because I don't think the order to return the planes is before you. So what we're talking about is not sending people, and that is
Foreign policy
straight removal. But
negotiations with
Okay,
the Maduro regime.
so let me address that. So
Well,
yeah, I know.
I will not stop you from having time to address that, but can you just tell me what's an example
Wow.
of the district court enjoining a national security operation with foreign relations
Right.
implications? I think we can at least agree on that.
So I think for one thing, I
No.
would cite Boumediene,
No.
the Supreme Court saying there has to be habeas. I mean, the government could not have argued more strenuously that the court should not interfere and say that they're entitled to habeas while they're at Guantanamo. But to your point about the national security, I want to return to something that Judge Millett said. The government cannot take the position that it's an interference by this court on national security grounds to give people process.
Three,
The Supreme
yeah,
Court
three.
was 100% clear in Ludecky in footnote 17 in multiple cases saying process. So for the government to say you're interfering by giving what Justice Frankfurter said in Ludecky was necessary as a matter of the act, I don't even think he needed due process. He was ruling as a matter of the act. You have to be able to contest. The implications of not giving people a chance to contest it are extraordinary. I mean, every religious and ethnic group in this country has at some point been tagged as associated with a criminal organization. If people can just be picked up and sent,
Mr. Glare, I mean, I just have to stop you. You're not getting an argument from this bench
Okay.
so far today against the idea that every single member of this class
okay,
can have an individualized habeas determination in front of an Article III judge to say, I'm innocent. And I think I take your point about Boumediene and your point about Ludecky, but I think it's hard to answer some of our questions without mentioning cases that are habeas cases. Boumediene was habeas, Ludecky was habeas. And so it seems like in order to answer one question in a way that is kind of satisfactory for your position.
well, that's because they were asking for release.
But you are asking to stop a transfer, and that is something that habeas has been used for.
Oh,
repeatedly.
wow.
It could be used, but it doesn't have to be used.
We got
have-
two judges fighting.
Your Honor, I want to return maybe to the very beginning of this appeal. We don't think there's jurisdiction over a TRO. I mean, you just had the decision in Bellinger. That's a very, very rare thing for this court to find that a TRO is appealable. And there are two preconditions. One is that it's a mandatory injunction not preserving the status quo. Judge Boasberg was explicit that he's simply preserving the status quo. And the other thing is that the harm can't be undone. You cited Mr. Kozak's affidavit. That's the last sentence in a two-page affidavit, which says there would be harm, but then he switches to could when he's talking about the short term. And all we're saying is
I
that
think that
this,
we as judges don't know everything that the State Department knows.
well, I think there's a reason why he switched from would to could in that sentence when he was talking about the short term. We're here asking that Judge Boasberg be allowed to do his work. And I think counsel for the government repeatedly answered questions to this panel by saying, I don't really know, there's not a factual record yet.
How do you just, on the question of whether this TRO is the type of normal TRO that can't be appealed or a type of unusual TRO that can be appealed, We have this Adams v. Vance case from 1978. It says that you
What?
can appeal that TRO, and he called it an intrusion on executive discretion in the field of foreign policy. And I know you maybe don't think that's what's going on here, but the government argues that's what's going on here. So it seems like
What?
if you lose on the sort of merits of this argument, you should also lose on the is it appealable part.
Well, I think, Your Honor, that Adams was very different because it was a mandatory injunction telling the Secretary of State what to do, and this is very different. It's preserving the status quo, and there was also a fuller affidavit.
I understand the planes are on the air now, but it was not preserving the status quo when the planes were ordered to be turned around.
Well, Your Honor, again, I'm not sure I have much more to say on that other than that is about whether the district court's order, a federal judge's order, was violated, but he still has not made any determination, so it is not before you. In saying that keep these people on the ground, don't let them be removed under the Alien Enemies Act. This is an unprecedented move to use the Alien Enemies Act for only the fourth time in our country's history.
3 judges.
Without a declared war, he's saying preserve the status quo until we can find all the facts. And I think what we're going to show in the district court is that many, if not most of the people removed had no connection to the gang, that the gang does not actually have a formal structure with members. We're going to put in evidence about what happens in a Salvadoran prison, that you could remain there for the rest of your life. We're going to put in evidence, hopefully, about what the timing was and who signed it. President Trump has introduced confusion about now whether he actually even signed the proclamation. So all we're saying is that Judge Boasberg is working very hard. I'm sorry.
No doubt. You can finish that sentence.
No, I was just
think
saying.
he's working very hard, and that he has had to move very fast.
And I think we're going to move on a preliminary injunction very quickly. And I think for this court to sanction
Oh my gosh.
anything about what the government's doing, or even to say Judge Boasberg shouldn't have time to figure out what the process is, so it's not an illusory ability to contest. Without a factual record, I think that is probably short-circuiting the way the system should work. I mean, we're really talking about something extraordinary to name a gang rather than a foreign country. This was a wartime measure meant for war.
Let me just, in terms of irreparable harm to your clients,
Right.
in terms of El Salvador prison that you just mentioned, all the things that you've just you just articulated. What's your response to the government's argument? You can maybe do all that, but you just got to do it in the right court. And the right court is in Texas, not
Yeah, Your Honor, I want to answer that, but I just want to make one other point. The government seemed to be suggesting that this was about pre-deprivation, as if there wouldn't be harm if they were in a Salvadoran prison for a few days. But I don't hear the government saying if you win that habeas, we'll bring you back from the Salvadoran prison. So it's a little bit of,
All right, my dear friends, I'm noticing that it is 2 o'clock. I have to leave my home. I have somewhere I've got to be by 2:15. I didn't think this would go this long, but it's continuing on. This will be available on YouTube. That's where I'm at right now listening to it. So I do know they keep their recorded arguments on there. So I'll be coming back and listening to what I miss when I have to go out and take care of some business. So, but thank you all for coming and hanging out. Wow, this is such a very, very interesting situation. I'll have to hold my thoughts until I hear the other half of this argument to figure out how I feel about how things went. So, yes, MSNBC, exactly, exactly. I'm so thankful, by the way, to Taylorina. She's the one that kind of gave me the heads up this was happening today. So I'm very thankful for that. Thankful for all of you that came by to hang out with me. I wish you the best of days, and we'll have to kind of chew on this and see how we feel about uh, this hearing. So take care, everybody. I'll see you again very soon. Have a good rest of your day.